This is Rivas versus Brian Fisher, Superintendent, Sing Sing Correctional Facility, number 13-2974 PR. May we have the appearances of counsel stated for the record? I know that each of you has signed in with the clerk, but I'd like to have the appearances stated for the benefit of the panel so we know exactly who's who. Beginning on my left.
Robert Moran, Assistant District Attorney.
Priscilla Stewart from New York State Attorney General's Office.
Richard Langone.
Sidney Maines.
Casey Johnson.
Edward Klein.
Thanks.
And Your Honor, that's Kim Zimmer, who assisted earlier on, and she's here with Mr.
He's your assistant?
She's assisting Mr. Klein. She was recently appointed by the state court to do the motion practice.
$515,000 paid to settle 4 lawsuits filed against Onondaga County and medical examiner Erik Mitchell. Investigators from New York State Department of Health notified families that Dr. Mitchell removed deceased body parts without permission. Serious allegations by staff at the Onondaga County morgue. New York State Department of Health investigation was widely reported by local media. Whistleblowers triggered investigation by the New York State Department of Health and Onondaga County District Attorney William Fitzpatrick. Dr. Erik Mitchell, Onondaga County medical examiner, removed body parts from corpses without consent. Reprehensible criminal acts included removing baby's brain who tragically died. Harvested body parts. Directed staff to chop up body parts and dispose by flushing the diced parts down morgue drain. Investigators found photos of individuals posing with corpses. Photographs were of a sex offender smiling and posing over corpses. Dr. Erik Mitchell testified at Hector Rivas' trial as District Attorney William Fitzpatrick's expert witness. Onondaga County medical examiner testified while under investigation by DA William Fitzpatrick. Listen to oral argument, Second Circuit Court of Appeals. Rivas Fisher. Compared to District Attorney Fitzpatrick's internal publication, attacks Second Circuit's decision. His article is replete with false facts, omissions of material fact, and distortions of fact. In contempt of ABA Model Rule of Professional Conduct. Das publication attacks the integrity of Circuit Court with false statements throughout. Accuses 3-judge panel of incompetence. Having bias against Judge Gary Sharpe and Judge Peebles. Asserting Second Circuit judges ignored the facts and executing a direct personal attack on him. DA Fitzpatrick article defends Judge Sharpe's refusal to comply with Second Circuit's mandate. Instead of following order of Second Circuit, Judge Sharpe applied blatantly wrong interpretation. His decision delayed retrial of Hector Rivas. Fact. These judges would never accept any finding against District Attorney William Fitzpatrick. District Attorney William Fitzpatrick could never convict Rivas in a fair trial. Knew Rivas had cancer. So he delayed retrial. Ran out the clock. Hector Rivas died in jail.
But I think context is crucial and the record should be entirely clear. Moving on to our discussion, I'd like to begin by asking Mr. Moran a few questions. I know that my colleagues will also have questions for Mr. Moran as well as for the other counsel who appeared today, and I don't wish to suggest that my questions in any way preclude questions that they will ask as soon as I'm finished. So, Mr. Moran?
That's me.
That's you. Let's start with the questions that our most recent order portended. If we were to order Mr. Rivas' release from custody pending resolution of the state proceedings, what is your view with respect to the conditions that we should impose and how those conditions would be monitored and enforced?
Judge, I don't know who you intend to have monitor him. I don't know how that's going to be accomplished locally in Onondaga County when people are released for what we call pretrial release.
Why don't you move up to the microphone?
The probation department would monitor someone and set up conditions that the county court judge might impose on him or her. But I simply don't know how this court's going to force Onondaga County probation to do that. They do it in other cases locally. I've never seen it done in a murder case, but it can be done.
Tell me what the problem is in having this done in the state court.
I'm at a loss.
And why, to put it another way, which comes to another question in a way, Why exactly is a $200,000 bond required in a case like this? Originally, the state court, after our initial decision, began with a $1 million bond. And we know that there is a constitutional right in this country to bond or to bail in appropriate circumstances. Was there a finding made that he was a danger to the community?
Danger to the community isn't relevant for bail considerations in state court.
Really?
It is only flight risk and the...
What is the risk of flight? Was there a finding on that?
There was no hearing. I made a representation to the court about the strength of our case. The court considered that argument along with the
Did you
argument...
make an argument on the basis of that there was little or no risk of flight?
I did not make an argument about risk of flight, that there was little or none. I said there was a risk of flight based on the proof in the case.
That there was no risk of flight?
No, I said there was a risk of flight.
Risk of flight?
On a level of proof, on the fact that if he's...
Who were you representing?
People of the state of New York.
Okay. And tell me more.
About the risk of flight?
Yes.
Representations I made to Judge Miller were about the strength of the case, and that based on the strength of the case, I said Mr. Rivas was a flight risk based on the strength of the case. I laid out the entire case for Judge Miller in making my bail application. Another factor the judge considers usually is ties to the local community, of which Mr. Rivas has none. And then based on that, Judge Miller makes a decision. He sets the bail, not me.
Now, at one of our previous hearings, Ms. Stewart was unable to detail with as much specificity as we might have liked what concrete and substantial steps the state had taken in the 60 days following the issuance of our March 11, 2015 mandate, quote, expeditiously to retry Mr. Rivas. Would you walk us through those steps, being as specific as possible? What is it that you've done to take concrete and substantial steps to retry Rivas, other than to announce that you're, quote, ready for trial?
I've done everything I can.
It's so difficult to listen to Mr. Moran, with all due respect. In the meantime, Hector Rivas sits in jail on a 30-year-old case. He has served 24 years, Your Honor. 24 years of a 25-year minimum sentence. 3 years ago or so, Judge Cabranes, your decision was spectacular, indicated and gave him a breath of absolute innocence, or actual innocence, excuse me. And yet he still sits in jail. He's terribly ill. He has no place to run. He'll go home to his family while Mr. Moran and Mr. Klein fight it out.
Where is his family?
In the Bronx, Your Honor. His wife is here. His wife is here. They have a home in the Bronx. Easily for him to go home. He's ill. He can't hide, Your Honor. There's no place to run.
Let me ask Mr. Klein. Afraid not, Mr. Stewart. It's very nice of you to supplement the record, but I think I can speak for my colleagues in saying that your statement just now is simply inaccurate. Our mandate specifically spoke of the release of Mr. Rivas if the state had not taken concrete and substantial steps expeditiously to retry Mr. Rivas. And we are here to determine whether or not the state has in fact taken concrete and substantial steps expeditiously to retry Mr. Rivas. And I think I can speak for my colleagues in saying that that is a challenging question, at least. We're not prepared to make any final decision on that. But I must say, we would not be here unless we had serious questions as to whether that mandate, the conditions set forth in that mandate, had been fulfilled. We are adjourned.
Thank you.